Be welcome to the fourth session of the international webinar, Trials for Recognition, Cultural Pluralism, and Rights of Minorities. Today, the topic is Indigenous Law and Indigenous Rights. We have different speakers, and our first speaker today will be Dwight NEWMAN from the University of Saskatchewan. Well, sorry for my pronunciation, from Canada. And the title of his intervention will be Peoples and Persons in the United Nations Declarations of Indigenous People. And it's your turn.
Well, thank you, and thank you very much for having me as part of this session. This series is, I think, a wonderful series and a good chance to discuss some important topics. The paper that I'm presenting is entitled Peoples and Persons in the UN Declaration on the Rights of Indigenous Peoples. The United Nations Declaration on the Rights of Indigenous Peoples, adopted via a General Assembly resolution in 2007, has various provisions within it that people normally talk about as embodying collective rights. And some scholars have drawn particular attention to that and said that the UN Declaration on the Rights of Indigenous Peoples marks a major shift in international law in terms of recognizing collective rights within the international law framework in a larger way than previously. I think there are interesting things to talk about just on that claim, in terms of to what degree the declaration does or doesn't mark a full recognition of collective rights, and I'll allude to that later. But my main topic is actually to point to the fact that the declaration isn't just about collective rights, even if it does offer some protection to them, but it actually ascribes rights not just to Indigenous peoples, as a number of articles do, but also to Indigenous persons at a clearly individual level. And it articulates relationships between rights held by peoples and rights held by persons in at least some of the articles within it as well. So I'm trying to talk about the complex place of individual persons within a declaration that's largely discussed in terms of the rights that it protects for peoples or for more collective entities. To do that, I talk about the text of the declaration and some background to the declaration, and I highlight there are a number of provisions that do contain what are clearly individual rights. I'll say some things then on the drafting history behind these provisions, and I'm going to highlight that those provisions on individual rights were often added, or were in many instances, I should say, added in later iterations of the declaration, while some other discussion was happening on collective rights at the same time, with a lot of states showing skepticism on collective rights. And so I'll talk about the significance there. I'll say something on there being several different categories of individual rights related provisions in the declaration, and then I'll try to wrap up with some things on the general significance. The paper is very much at a draft stage, so I'm very welcoming of comments and questions in order to then do a revision of it on the timeline for the publication ensuing. So turning first to the background on the text and discussing these quickly, and I see time's moving on rapidly already. I'll just say again that the declaration was adopted as a declaration at the General Assembly in 2007. I don't want to dwell on the complexities of what that means for its status at international law. It's certainly having an impact in various places. In New Zealand, at least some of the judges of the Supreme Court have cited to the declaration in several different judgments. In Canada, there's legislation to implement the declaration that's been adopted in the province of British Columbia and is on the federal agenda as well. It's having an impact in a lot of other places as well, but those are just two quick examples. It is a distinctive legal instrument insofar as in many ways does seem to entrench collective rights. But it is, I want to highlight, less explicit on this than it might have been. So it does entrench collective rights insofar as a number of articles recognize rights held by Indigenous peoples who are collective entities. However, the term collective rights was present in numerous articles of the 1994 draft declaration, and though the uses of the term collective were almost universally removed prior to the adoption of the 2007 final declaration. And there's some literature on some of the concerns that states had around the concept of collective rights and some debates that went on around that. Particularly around 2004, 2005, 2006, there was a lot of discussion around this, not the only time. There are now only a small handful of uses of the term collective within the declaration in its final form. I'll come back to those quickly, time permitting, near the end. So a number of states had concerns about the very idea of collective rights and resisted the presence of that term in the declaration. A number of states, upon voting for the declaration, also offered commentaries or interpretive statements indicating that they still didn't accept the concept of collective rights. The United Kingdom, France, Japan amongst them, and they're not the only ones. So there is a scholarly read, and I think a defense one, that it still does entrench collective rights, but there's a view by a number of states that they were actually looking to express something different. And that could include individual rights exercised in community, which those states do accept. I think it's not coincidental that during this time you also had the addition to the declaration of a number of individual rights. It brought it more in line, as far as those states are concerned, with aspects of human rights law. But there are provisions that still do reflect something further. And Article 35, for example, says Indigenous peoples have the right to determine the responsibilities of individuals to their communities. That's challenging to reconcile with some other things. There's more to discuss. I'm not going to spend a long time on those. I need to move along. But I will say in the third part then, that the declaration has a significant number of references to individuals. So apart from these provisions that do recognize collective rights and even say something about that relationship where collective Indigenous peoples regulate individual rights, it has a number of references to individuals and significant references. Some of those are reasonably standard human rights. So Article 2 protects both Indigenous peoples and Indigenous individuals from discrimination. Article 7, sub 1, provides that Indigenous individuals have the rights to life, physical and mental integrity, liberty, and security of the person. The very sort of thing one might find in an entirely individually oriented Bill of Rights in various states. And we could give various examples of that. Some, though, are more complex and create a sort of nested human right. Article 14, sub 2, provides Indigenous individuals' rights to equal education, embedded with the article providing for Indigenous peoples to control their own educational systems in their own languages. So there's a combination of some individual right within a more collectively oriented right around an educational system that are sort of nested together, as I put it. And then there are also some that express conceptual relationships to the state entities with whom the rights are in interaction. Maybe not always fully consistently, but there's some very complex things going on in terms of the shift the declaration is trying to effect. Article 6 says that every Indigenous individual has a right to a nationality. which arguably reinforces the Westphalian state system that many saw the Declaration as challenging in some respects. But at the same time that Article 6 might reinforce aspects of the state system, Article 8 provides that Indigenous peoples and individuals have the right not to be subjected to forced assimilation or destruction of their culture, which would naturally limit certain kinds of nation-building policies that tend towards assimilation. In any event, I think there's actually a very complex and careful reconciliation of different rights to be found in the Declaration. And the Declaration actually has to mediate between collective and individual rights in some complex ways. And what's the broader significance of this? Just speaking briefly to that before I wrap up in a minute or two here. I'll just say, first of all, in recognizing various rights held by peoples, the Declaration does move meaningfully in a direction of recognizing collective rights. And we could say more about the significance of that. But there's this limitation on that compared to what it might have done. And the final language actually largely lets states objecting to the idea of collective rights to continue to maintain those objections and to conceive of the rights as more individual rights exercised in community or through peoples. Peoples aren't stated as holding collective rights as they did extensively within the draft declaration. So in one sense, the presence of all of these individual rights and the way in which the collective rights got redescribed in the final drafting process puts some brakes on the process of the shift towards collective rights that the Declaration might have represented. So that's one broader element of broader significance that comes out here. The other element that I would highlight is that in some ways, states largely succeeded, the states that had concerns with collective rights largely succeeded in overwriting explicitly collective right with individual rights. In the process, I'm not sure that the Declaration reflects as much of Indigenous worldviews as it might have, but there's much language in the Declaration that remains capable of an evolving interpretation that would give more recognition to those Indigenous worldviews over time. And that's the element that's certainly been preserved there in this complex balance between collective and individual rights. I think it's important to recognize that. It has some things to say about the process of the negotiation of such an instrument, the very messy process at times of the negotiation of an innovative instrument that's defending the rights of peoples that had been largely disregarded by states for all too long. In the process, we end up with a complex instrument, and there will be complex interpretive questions to come. There's much more to come over time, and I think a lot of work to keep doing on just what kind of rights the Declaration does embody in order for it to realize all of its purposes. So I'll stop there and say, simply, that's what we engaged with in this paper, thinking about not just peoples, but peoples and persons in the UN Declaration on the Rights of Indigenous Peoples.
Okay, thank you very much. Very interesting speech, and well, I will ask the questions as discussion later. First is the intervention of all the speakers, and now is the turn of Pedro AVZARADEL, who presents a paper jointly with Camila, GRAÇA, CAMATTA. Pedro is from a Brazilian University of Rio de Janeiro, and GRAÇA, CAMATTA is from the Universidade Cândido, Mendes, also from Brazil. And the paper title is a critical analysis of the Amendment Bill 215/2000 to the Brazilian Constitution and the Indigenous People Rights in Brazil. Pedro, it's your turn.
Hello, everyone. Good afternoon, good evening for those who are in Europe. I'm trying to share the file. I think I'm having a little trouble here.
Yeah,
Okay, share now. Okay, maybe it's going to work, I believe. Okay, so can you see the presentation? Okay. Well, thanks. I would like first to thank the organizers for the invitation. Me and Camila CAMATTA, we are very honored to be here. I'm doing the presentation, and then Camila will join us for debates. Camila was is former student from University Federal Fluminense, where I teach environmental law, and she was also part of the studies group on environment and law, the GEMADI group, which I run together with Professor De Carli. And we wrote this paper originally in Portuguese, and then we did an updated version, and also it was a shorter version when we translated it to English. This is why what we are presenting here today to you. Well, okay. So I think it's well known that the history of Latin America and the history of Brazil is marked by the continuous forcing and forced displacement of indigenous peoples. Our latest constitution, 1988 constitution, starts a new period where, at least in constitutional terms, indigenous rights are fully recognized. And in this sense, demarcation can be described as a cornerstone, and we'll be seeing that in details during our presentation. Basically, the purpose of the marking or marking out is to set a physical perimeter, and that is supposed to add certainty to indigenous rights. Well, I can tell you that they know pretty much well their own lands, their own territories. The problem is they're non-Indians. The problem is us. So here, when we set some boundaries, it's and we get some advertisers to say, hey, this is indigenous land, please keep out. This is a way to protect indigenous. And you can see on the right corner up, we can see here that unfortunately, in most cases we have invaders that use violence and guns and gunshots to force indigenous people out of their land still today. Well, when we look upon our constitution, we can see that Article 231 recognizes the original rights of indigenous people to their lands, the lands that they traditionally occupied. Those lands, they are submitted to the union's domain, but that's not a traditional property, because the constitution sets the finalities and the priorities to those lands that are entitled by the union, but are granted for the permanent possession and exclusive fruition by the Indian communities, original communities. So this is why these lands, they are not transferable, they are not subjected to limitations, and any contracts or acts looking forward to not to respect this constitutional rule, they are not valid, they are null. So we were supposed to finish the marking indigenous lands in 1993, 5 years after our constitution was enacted, but that just didn't happen. So demarcation is foreseen in the Indigenous statute, is a law from 1973, still with the previous conception. So it has to be interpreted along with and according with our constitution. And we have a federal decree from '96 that established the procedure. The procedure is a very technical one, and it's carried out by a group. It's teamwork, usually under the leadership of an anthropologist. It's a technical procedure that ends with a opinion by the agency. So Indigenous National Foundation, it's the indigenous agency in Brazil. And after that, it goes for ratification or homologation by the presidency. And after that, it goes to registration. As it is Union's domain, it goes to the office of the Union's domains. We call it SCPU, Secretaria de Patrimônio da União. So today, after the procedure is done, we have this phase, ratification. So in Brazil, we call it homologação. And it's a duty of the president, right? Of the presidency. But the proposed amendment 215 aims to transfer the power that ratify duty from executive branch to the parliament. And when we look around the parliament, not only we have just few cases of indigenous that managed to be elected for the Chamber of Deputies, for example, but we have groups that are clearly anti-Indians, and they are articulating in order to block the recognition of new territories. They want to question existing ones. They want those land grabbers and those who have occupied with new contracts and new acts. They want them, if they are to be placed out of indigenous lands, they want them to be granted an indemnization. Also, this proposed amendment seeks to adopt what we call the temporal landmark. This temporal landmark is a thesis that was adopted by our Supreme Court in a specific case. And in this case, is not what we call abstract constitutional control. It's a concrete case. So the effects of the case stay just among the parts, those who were part of the challenge of the dispute. Even in that decision, it says clearly that it doesn't apply in certain cases. But this is that in order to be considered a indigenous protected territory, the indigenous should be there the day our constitution was enacted, October 5th, 1988. So if we manage, if they manage to apply this proposed amendment, and that applies to all cases, I think we're going to have a lot of indigenous peoples that are still waiting for demarcation, and they might have some setbacks. They might not have that rights recognizes. This proposed amendment also brings a whole new range of exceptions. So today's illegal activities, illegal logging, illegal mining, just to quote some, will turn into legal activities, among other setbacks. So for instance, it will authorize, if approved, the exchange of indigenous lands in case of disputes. So there is a dispute between farmers and indigenous lands. Okay, indigenous, you go elsewhere. You're going to find you another place. And farmers, you stay. Cattle raisers, stay. Miners, you stay. That could make some sense if indigenous fought like us, but they do not. So land for them is just not an asset. It's just not only a material asset. Okay. So Camila and I, we brought some constitutional considerations in order to show, in our opinion, based upon studies and other legal opinions, that this proposed amendment, constitutional amendment, is unconstitutional. It's not compatible with our constitution. The first argument, separation of powers, which is a immutable clause, and that is due to the very technical nature of the State Act, and also the very technical nature of the procedure, but also because the rights of indigenous peoples are fundamental rights, and as such, they can be applied, and they shall be applied directly from the Constitution. They don't allow to be enforced, and no law could limit their range. So what I'm saying is that the law today established a procedure to recognize a right that is established on the Constitution. If that proposed amendment passes, then we'll have the possibility of a law passed by Congress, Parliament, to say no to that right established on the Constitution. So, and as I've seen before, as I told you before, access to land, access to territory is fundamental. It's very important to guarantee not only human dignity, but also cultural identity of those peoples, indigenous peoples. So their relation to land is not only a material asset, it's a spiritual and cultural relationship. And this is why it's directly linked to their development of personality rights, individual rights, and also collective rights. I believe that our time is running out. I know we have lots of challenges concerning indigenous peoples. I brought also some extra material if we want to debate that too. But I think our time is just running out. So I would like to thank once more everyone. I'm sorry if I made some English mistakes. It's not it's not usual for me to speak in English. So me and Camila would like to thank you very much, and we stay at your disposal for debates. Thank you very much.
Thank you, Pedro. It was very interesting. And now is the turn of Chiaretta Giordano, who is currently doing a PhD in the University of Tel Aviv. And the title of her intervention is Indigenous People and Food Security, Legal Obligation Towards a Right to Cultural Food. Chiaretta, it's your turn.
Thank you very much. And thank you, the organizer of the webinar, to give me the chance to expose my research and hear thoughts about it. As you might have read in the paper, this is just an elaboration of the introduction of the dissertation that I'm writing in Tel Aviv University in Israel, under the supervision of Professor Ayer-Gross. My PhD consists in a multidisciplinary research that concern the food security of indigenous peoples and space from nutritional anthropology and social psychology of food to economics and jurisprudence. So several studies on nutritional anthropology have proved that food choices are mainly influenced by the culture that first of all distinguish a group from another, and also reinvigorate the heritage and identity and generate a sense of belonging and safety. Therefore, the importance of maintaining the tradition in any culinary environment has a significant role in the promotion and safeguard of the individual and the as well. Notwithstanding the acknowledgement of the influence of culture in diets, nowadays food is mainly considered as a commodity. The neoliberal food system focuses more on the quantity of food and the Western diets rather than the quality. And the capitalistic system guarantees availability of food, which not necessarily includes adequacy. In other words, we lay on the assumption that international law can defeat food insecurity, just reducing hunger. But however, food security is not only confined to the concept of nutrition, but it also owns an action range on the psychological level that cannot be just solved increasing food production. In elaborating my thesis regarding the inclusion of culture in the food matters, I chose to focus on indigenous people as extreme case where it is highly visible the bond between community and cultural identity. In 2010, the United Nations Permanent Forum on Indigenous Issues said that the impossibility of indigenous people their identity according to their specific culture has started an escalating process of ethnicities extinctions. So given this correlation between cultural identity and existence, my research shows the significant role of ensuring traditional food. The strong connection of indigenous peoples to their heritage is the key element of the research. Each ethnicity obviously is unique and have diversely embraced globalization. For example, if in the past the relocation in urban areas was mainly forced, nowadays is also voluntary and accepted. However, many ethnicities still resemble for their connection to their ancestral lands and the natural resources that they are using in their daily activities and meals. So for this reason, indigenous people set a clear case study for my research. Why? Because the modern food regimes that which epitomize biotechnologies and monocultures are in conflict with the indigenous ideologies of food that is a balanced discourse between humans, spirits, plants, and animals. Indigenous people are the first inhabitants that have lived continuously on a certain. After centuries of living in the same areas, in the same territories, learning the most helpful way to utilize the surrounding natural resources and handing down discoveries and knowledge from generation to generation, native communities have shaped, among other costumes, also a culinary tradition that is a mix of natural medicines, ritual, symbolism, and also cooperation among the members of the community. Therefore, if from one hand, indigenous food provides the basic nutrients essential for their health, body microbiome, on the other side, it represents a way of life to which the member of the community identify. For my research, I used some studies on indigenous people in the United States, Canada, Australia, and New Zealand. And they all show that as soon as indigenous people have limited access to their traditional meals, not only they face malnutrition and chronic disease like obesity, diabetes, cancer, or heart disease, but they also experience loss of identity, loneliness, and threat to their ethnicity. So the vulnerability of indigenous communities proves that there is a gap in the international normative right to food that still hinders the achievement of the food security of indigenous people or even other communities that are not studied yet. For instance, new research have proved that the microbiome of indigenous people results to be totally different from the rest of the population, so maybe even other communities that are not analyzed yet. Therefore, both medical data and anthropological studies on the relational and symbolic meaning of food give us reason to reconsider the concept of the right to food. According to Mowbray, for example, the right to food still has limitation in addressing world food insecurities because it does not adequately address culturalism. So the paper proposes an introduction of the reason why a right to cultural food should be claimed. First of all, the right to cultural food could be defensible under the claim of cultural rights. In autochthonous communities, for instance, food does not converge only into the meal that is served on the table, because the traditional dishes are only the final result of a process. They are the result of knowledge about the use of specific medicinal herbs that can, for instance, can help children to grow up healthy and defeat diseases that are or even digest their food. It's about the observation of fauna and flora, the performance of sacramental rites, or even the partition of various duties among the members of the community when the meal is served. Hence, indigenous food represents a specific way of life which carries an intergenerational knowledge on it and distinguishes the ethnic community from other ethnicities and the rest of the population. The right to cultural food would therefore allow the understanding of culture as including food and vice versa, and extrapolating the concept of food from any economic dependence. Secondly, if traditional food safeguards integrity, the right to cultural food will be eligible under the protection of self-determination. Self-determination is the need to pay regard to the freely expressed will of people so that justice, stability, and autonomy are guaranteed in the remote future. Hence, the recognition of a right to cultural food under the claim of cultural rights promotes the acculturation of food, while the right to cultural food under the claim of self-determination encourages the understanding their right to food both as an individual and collective rights. Finally, integrity and identity demand dignity. So usually more than 50% of indigenous people have diabetes, and indigenous people living in developed countries have 1.5 times greater risk of obesity than other people residing in the country or in other nations. And this proportion between indigenous and non-indigenous people in health in urban areas shows a grave violation of human rights. So this article does not intend to deal with all the questions that food queries in the international human rights law, and obviously are deep in my dissertation, nor to reduce all the causes of indigenous people food insecurity to the mere lack of legal protection of traditional food. More modestly, the article brings the case of indigenous people food insecurity to acknowledge the seriousness of including traditional food in the international debates and national policies. So using the word of on the belief that minimizing the risks of a traditional diet is essential. However, promoting and maximizing its benefits, it's an emerging challenge. Thank you so much.
Thank you, Chiaretta. We have followed all the explanation, but there was, I think, I don't know if my connection or your connection, but we have some problems with the audio. Probably is my connection, but we followed your explanation. Was very interesting. Okay.
Thank you so much.
And now is the turn. María-Cruz LA CHICA, who holds a PhD from Universidade Complutense de Madrid, and also is currently a researcher of Universidade. The title of her intervention will be Current Situation of Women's Rights in Latin American Indigenous Regulatory Systems Towards a State of Affairs. María-Cruz, now is your turn.
Thank you very much. Hello all, and thank you those for the organization of this webinar. In this paper, I will talk about the current situation of women's rights in Latin American indigenous regulatory systems. There is a widespread absence of debate on the social, political, and legal situation of indigenous women in Latin America, although more recently, there seems to be some noteworthy exceptions and progress in this field. It falls short when compared with the extensive academic activity that exists on subjects concerning indigenous cultures in general within the field of anthropology.
María-Cruz, I think we cannot hear you.
Yeah. Ah.
Okay.
Okay. Sorry. Okay. Sorry. I have to start. Sorry. Well, in this paper, I will talk about
the introduction.
Okay.
The introduction we have here this slide, but the next slide we didn't hear anything.
In this
slide we didn't hear anything.
Okay.
Yeah, this is a slide we didn't hear anything.
Okay. Indigenous women in Latin America are constantly exposed to and suffer from a specific type of violence that is the result of the intersection of race, class, and sex, caused by a range of societal factors and perpetrated by various agents. But for the purpose of this paper, I will focus only on oppression suffered by indigenous women through their traditional indigenous institutions. Some of these practices are more or less known to exist among those academics like me who have undertaken anthropological field work in this space. However, there are relatively few studies on this subject, coupled with few official statistics. Indigenous women remain invisible. On the one hand, because of the absence of questions of ethnic identification in the continuous records and surveys, and the other hand, because of the cultural inadequacy of the statistical instruments. This prevents a thorough knowledge and understanding of the situation in which indigenous women and girls live, and it is an obstacle to the formulation of strategies that are effective in addressing violations of their rights. The oppression suffered by indigenous women through their traditional institutions is often coined as being in the name of custom and articulated within their normative systems, and is defined by the Committee on Elimination of Discrimination Against Women as harmful practices. The following 10 examples and cases that I will put forward in this presentation aim to demonstrate how some indigenous institutions, for the sake of their customs, discriminate women. For example, the capital punishment was used for wives who commit adultery in the Frias province on the Potosí department in Bolivia. We also have data on female genital mutilation practices, at least among the Emberá indigenous people in the departments of Valle del Cauca, Risaralda, and Chocó in Colombia. Cases of the sale of indigenous women for the purpose of exploitation have been reported in Nicaragua. It is very common, at least in the Los Altos de Chiapas, where I have been in anthropologist research, that in cases of rape, the process and conviction is suspended if the rapist promised to marry the victim. On the issue of child marriage, for example, in the case of Mexico, during 2011, 15% of marriages celebrated were of girls between 12 and 18 years old, being more vulnerable to this practice the population that suffer more poverty and that are indigenous. Somewhat better known, although very irregularly systematized, are the cases of violation of women's political rights within indigenous regulatory system. The indigenous institutions where conflicts are resolved are usually male. In the state of Oaxaca, Mexico, of the 18 municipalities governed by customs and traditions, women hold political office in only 9 of them. That is 2.1%. Moreover, of the total number of indigenous municipalities governed by their own systems, women do not have the right to vote in 43 of them. The lack of women political right has serious implications. For example, in the consultations that the state sometimes carries out for decision making on the territories in which indigenous people live, because women's voices are not represented as their right to free, prior and informed consultation is thus violated. It also has a great influence on the very frequent cases of domestic violence. When women seek justice from traditional authority for defamation, neglect, rape or domestic violence, they often face lengthy processes where the sympathy of the authorities is not exactly on their side. With regard to land rights, there is also a great inequality. The indigenous custom reproducing ejidos in the ejidos recognizes property ownership only for men. This is in many cases of Mexico. The rights of community members who live or marry a non-indigenous or indigenous person from another community are not the same for women as for men. While for men it is accepted that women who are not from the community join the community, women face obstacles. The lack of data is overwhelming, and we live with too many unknowns. We do not know, for example, in how many indigenous communities in Mexico the rape victim is forced to marry the rapist. In how many cases it is permissible practice for the father to sexually abuse his daughters or stepdaughters and take them as his wife. We do not know in how many communities and how often human trafficking exists in the form of what many anthropologists have called a dowry for the bride. We do not know in how many communities women do not have access to positions of political authority or even to vote. We do not know in how many communities where women may have the possibility of being in a position of power, their husband actually hold that power instead. We do not know how many cases of child marriages there are per day and in which communities. We do not know in how many communities women are excluded from inheritance nor do we know in how many communities they are expelled for not obeying community rules. And what I have to say is if we don't know this data, we are forced to navigate through the challenge of trying to understand the degree of naturalization of the oppression that women experience and the neglect of the state in its obligation to care for them with minimal empirical data. In short, we can state that women are not in a situation of equality with the men of their community, and that they suffer different forms of oppression that are interwoven with their institutions, customs, and normative systems. The violence they experience, as we have seen, is serious and widespread and requires an official description based on empirical data that gives up an accurate view of the dimension of problem. The practices described above are an indication of the discrimination against indigenous women which exist in community context. These practices are based on belief that women are inferior to men, arranged and prioritized in explicit or implicit oral or written normative systems, and imposed to the traditional formal institution responsible for exercising coercion. In the second half of the 20th century, with the specification of rights imposed by international human rights organizations, indigenous people have been recognized as having the right to administer justice and live in accordance with institutions, customs, and regulatory systems. It is true that no legal system recognizes that the rights of self-determination stand above individual rights in the normative pyramid. However, considering the position that most indigenous women have in such normative systems, the recognition of such collective rights should have posed, at the very least, a dilemma. Based on the Convention 169 of International Labour Organization of 1989, which is binding, Latin American states began to recognize indigenous jurisdiction in their constitutions, so that the region has become a veritable lawmaking laboratory. Colombia was the first Latin American country to recognize indigenous jurisdiction in 1991, followed by Peru, Bolivia, Ecuador, Venezuela, and Mexico. And now, could we imagine that international organizations and states would have validated normative systems so quickly and with such relevance if most of them had systematically discriminated against men? Could we imagine the major human rights organization urging states to recognize in their constitutions normative systems that prohibit men from owning property, participating in political life, or having no decision-making power over their sexuality? Indeed, it seems clear that international law, state law, and indigenous law share a patriarchal vision of justice, and that their discriminatory bias towards women allows them to naturalize their inequality. The problem is that constitutions recognize normative systems, institutions, and customs with materially describing and perhaps without knowing what they are and what consequences they have, especially for women. In other words, they are in a vacuum. The violence suffered by indigenous women within their communities is entirely articulated in their cultural institution, so that irremediably, if these are validated in a vacuum, that oppression is reinforced. If states recognize institutions and norms that systematically violate women's rights without knowing them, then they are also responsible for their consequences. The question of whether the collective rights to self-determination of indigenous people are incompatible with the human rights of indigenous women is misplaced. The cause of oppression is not the plurality per se. If that were the case, oppression against women would end if legal monism were installed, and this does not seem very possible. Pluralism can be neither good or bad if it does not take into account the contents and consequences of certain norms, customs, and institutions that such pluralism validates. Today, legal pluralism does not provide the mechanism to rectify the unintended consequences of its exercise when women are systematically oppressed as a result of the very norms, customs, and institutions that it validates. And if it could be necessary to see in each case, in each community, who the indigenous people are, and if they are also indigenous women, who are recognized as having the right of self-determination, and to know on the basis of which normative systems, values, and institutions this right is going to be articulated. Only by answering this question can we answer the question of compatibility. The problem we pose here challenges Latin American states in two ways. On the one hand, it demands from them an effective response in descriptive terms that offers a complete and detailed official data map of the situation of indigenous women's rights in each of the communities, and so make it possible for us to know the size of the problem. On the other, It demands from the states a response in terms of the compliance with the conventions and human rights treaties to which they are party. This clearly indicates the superior hierarchy of individual human rights in respect to collective rights whenever this conflict. Thank you very much.
Thank you, María-Cruz. Very provocating and interesting speech. And finally, we have Monique Falcao from Santa Úrsula University with the title Ethnic Minorities in Brazil, Conceptual Aspects. Monique, hello.
Hello. Hi, can you hear me?
Yeah, we can hear you. Yeah.
So I'd like to share some PowerPoint. Sorry, if possible.
Have you uploaded? Oh, yes, it's here. Yeah, I share now.
Thank you. Okay, now everybody can see. Okay, so first of all, I'd like to say that my main research is not on indigenous people, but in quilombolas. That was my PhD thesis, and I was looking for some conflicts that the quilombolas were suffering in Brazil, to understand a little how identity and recognition can be affected by those social conflicts. And so, to go a little deeper, we decided to make some to see how the speech, how can I say, the discourses and the speech about the concept of quilombola were working in the institutions in Brazil. So there were a lot of different meanings for those quilombolas people. So in this paper, I will just show a little how the quilombolas did the different meanings since the slavery time until nowadays. How did it get a little different? And to show how the post-colonialism perspective did affect this. This has built the new conception that we have now in our latest constitution, and how does it impact also the social conflicts? So that's the objective of my work. And the empirical field of indigenous people, that's a research I'm starting now. So that's why I don't have yet a lot of data about this. I mean, my own research data about it. But also I am in a panel where we are talking about indigenous people, and Pedro and Camila had already presented in a very proper way the legal regime we have nowadays there and the constitutional regime of land possessions for indigenous people in Brazil. And they also showed a little the main conflicts we have in Brazil involving this ethnic minority in Brazil. So once they already did this part, I will focus a little to show the other part that are the quilombolas, and I'll also show a little I would say how the conception of indigenous people has a little change also in Brazilian history. So this work is more descriptive than critical. Yeah, that's more descriptive than, I would say, critic. Yeah, that's it. So I will start with the quilombolas, and then I will show a little the indigenous people. So quilombolas, it's quite interesting because, as people know, in Brazil we had the slavery time where we had the slaves. They were the Africans, black people, the Africans. They came to Brazil as slaves. So at that time we had a historical legal conception of quilombo and slave that was they were object of law, and the quilombos, as you can see here, as a group of escaped slaves placed very far away from landlords. And the legal regime for quilombos is that they were illegal, and so the slaves were object of law, and the escaped slaves living in quilombos, they should be arrested and returned to landlords. So that's, I would say, the legal discourse, the legal speech. This legal discourse, this legal speech, it comes until nowadays as a common sense. And it has a lot, this is the foundation of discrimination and prejudice we have nowadays in Brazil, I would say like this for this first talk. But now the post-colonialist way of thinking, and in Brazil, it's in Latin America, it's seen as an emancipatory instrument for these ethnic minorities we have there. So in a post-colonial way, of to see these things, the critical anthropology and the historiography, they decided to, I would say, re-significate those social actors. And so they could see in the social reality, not in legal conception, but in social reality, they could see that many quilombos slaves and ex-slaves, they were really economic and social actors, yeah, and they were really integrated to economy of cities and farms, and they had some power. They had political power, they had some economic power. That's not the most part, but they had. So nowadays, on our last constitution, we had this article to protect the quilombolas and the quilombos. So that's the first time, this is important to say it here. That's a huge difference between quilombolas and the indigenous people. Indigenous people in Brazil, they always had some kind of protection. They always had the land they occupied, always had some kind of protection. In colonial times, they had protection from the Jesuits. They also had some protection in the empire time from the Portuguese throne in Brazil. And all constitutions in Brazil somehow protected their land. This is important because for the quilombolas, no. For the quilombolas, the first time our legal framework or our constitutional history, I would say like this, recognize them, recognize some rights, and recognize them as a community that should be protected is our last constitution. So since then, there was no specific protection for them. The slaves, the slavery in Brazil were finished in only one act in 1889. Since then, the black people, the ex-slaves, they just were like everybody else. They had no special regime, no special acts or legal regime to be included in the society. So they just became, from night to day, subject of law, and so they should look for their rights just like everybody else. So this lack of inclusion is seen by most part of our historians and people who studies these things as a main reason for our contemporary big poverty that includes black people, and discrimination and prejudice, and as everybody can see, for instance, favelas and all these things. So there's a huge literature about this. Yeah, this is one also discourse, one also speech, but this is all. This is a good explanation that is fully, I would say, known in academy. So the legal regime for quilombolas nowadays, so the first time they are recognized as a community and they have their traditional lands protected is from our last constitution, and the legal regime is this decree, which was declared constitutional, confirmed as constitutional by our Supreme Court. This is also a very important information. So, okay. So, we have this. First of all, we have the official recognition of quilombola self-identification. So, we must have an official anthropological report from government. So, here we have a very important conflict, which I will show in the next slide. Second step, this is the delimitation of the quilombolas territory. So the quilombolas territory in public or legal protected areas, military, national security, for instance, and the expropriation of private lands. In the first case, when there is quilombola in public or legal protected areas, they must become compatible both. I mean, quilombola normally stays in this area, and they have a kind of agreement with the institution responsible for this land to try to have a convivence. But when these quilombolas, they live in private lands, so it must have an expropriation of private lands. 3. After this, it must have the titration as indivision of quilombolas property. So this is interesting because the quilombolas property becomes indivisible, and in a legal way, it only can be possible. I would say the decree says it only can be possible if the community become a civil association. So the land will be registered in the name of the civil association, not in name of the persons, the people who are members of the community. 4. The effects of titration as legal protection of quilombolas property: no alienability, no prescriptibility, and immunity from seizure. So these 4 main points of the decree, I identified in my thesis that they were the 4 main reasons for the I will show. So in the first step, the main conflicts are that the official anthropological report is criticized because it is seen as an instrument, can be seen as an instrument of control from government. And also there's another problem that there are some communities in Brazil that just they learn some traditional activities. They learn some stereotypes to reach this official recognition. This is the hardest critique that these communities receives from civil society in general. Yeah, that they don't have. They just learn the stereotypes. For instance, feijoada and all the capoeira and the other old dances and old costumes that the slaves time they used to have. They try to learn something now. That's this. The second step of quilombolas territory delimitation, we have here the main conflicts. They are the restriction of use and physical delimitation because of legal protected area. So just like the indigenous people, when the indigenous people always also have their lands inside some area that's protected because of environment and all these things, there's these conflicts where they must compatibilize the use of the land and the protection, the legal protection. So when the quilombolas are in private lands, they received attacks from private landlords against expropriation, and also as we had, and we had one lawsuit for inconstitutionality of quilombolas property. This lawsuit for unconstitutionality was not accepted by our Supreme Court, but we know that there are other lawsuits, not only in Supreme Court, but also in the whole judiciary power. There are a lot of lawsuits trying to somehow delegitimate or become illegal the act to recognize quilombolas property. Okay, so going on the conflict, the third step, indigenous titration for quilombolas property. The main conflicts we can see here are they are internal in the community. The community is built in a familiar and communitaristic way, which means that normally they have no formal hierarchy. And when they need to become a civil association, there are some communities which have just breakdown. Some communities just could not understand and get adapted to this new reality with this kind of this hierarchy, and so they just break down. I mean, it could not be finished, the process of recognition and protection of the land. And therefore, the effects of titration as legal protection, that's the main problem here, is that the property becomes out of market. It has no economic function. It can be in a first view, we can see, oh, this is good because actually the land will be protected. It cannot be sold. It means that the community will be protected because the community will not receive any menace anymore from economic actors. But the other thing is that, for instance, they receive big attacks and very hard attacks from real market and agribusiness in a preventive way to avoid the consolidation, to avoid the titration of quilombolas property. And after, if they reach the consolidation of the recognition itself of the quilombolas property, they have another problem, that they cannot use the property, for instance, as credit and any other kind of specific commercial activities. So the community, they cannot develop economically, I would say like this, yeah. And of course, the chances for competition get reduced, yeah. So they are the main conflicts for quilombolas. Okay, now I'd like just to show a little some about the indigenous people in our Brazilian history. So the legal design that we have, a traditional for indigenous people, that just like I did for quilombolas to explain how was the legal regime for the slaves, I'd like to show the legal regime, for instance, just very quick, because this literature is very big, is very long, and I'm still getting deeper on this topic. So I just showing some superficial results, I would say like this, yeah. So the legal redesign in a traditional way, the colony, the imperial legislation, we had on one side the economic exploitation policy from the landlords, from the Portuguese crown, and from national interests, I would say like this. And on the other side, we had the integration and assimilation policy, yeah. the indigenous people, they were not object of laws. Only few of them, or the period where the indigenous people were considered as slaves, or they were used as slaves, or they were used for work. This was quite, I mean, officially this was a small period, but unofficially this was a long period. This is something very interesting, because even if we used to have some legal regime protecting somehow the indigenous people and their lands somehow, but in practice they were used for as maneuver. They were used as, how can I say, as force of work. Yeah. And this was interesting because also the indigenous people, they could not reach the information, and they did not have some force, some strength to know the protection and to fight for this protection. They used it to become, yes, unfortunately, but they used to become also force of work. Yeah, so the legal regime was one thing, and the practice was very different. And in our Brazilian history, we had some periods that called fair wars. We called it like Guerra Justa, and in which in these periods they were allowed to take these indigenous people, for instance, to be civilized, to be Christianized, and also to become slaves. Yeah. So these periods of fair wars, I would say something like that. There were some periods where the indigenous people, they were attacked. Yeah? And on the other hand, we had also some other periods in which we had some embryonic regime of possession of occupied land for indigenous people. So there were more diverse, this kind of regime for indigenous people. In 500 years, it has changed a lot. But in a social reality, the post-colonial way of remaining, I would say like this, the participation of indigenous people has also seen indigenous people as historical subjects, giving him some emancipation, and also seen active participation in economic and political life, having in some cases negotiation power. Yeah. So this is quite similar. The epistemology behind these speeches, these discourses are quite similar. Yeah. So the foundations for the construction of critical anthropological conception for indigenous people in Republican period, because then become really different, because the just wars were completely extincted. It means that the indigenous people, they could not anymore anyway become slaves or become Christianized or something like that. So in the beginning of the 20th century, we had the official creation of Indian Protection Service. With the civil code recognized them as relatively incapable. It means that the state should give him tutelage. They had some kinds of civil capacity. And the Brazilian constitutions progressive, detailed, and get deeper in protection of indigenous possession of land. And the last civil code, from 2002, did not regulate civil capacity for indigenous people, just left transferring this regulation to specific laws. These specific laws are actually the Statute of the Indigenous People that Pedro had already talked about, and it has still a perspective integrationism. This is interesting because in this statute there are 3 levels of integration for indigenous people. I mean, at least 3, yeah. Like there are the indigenous people who has no contact with white society. So those one, they would have no civil capacity and no criminal responsibility, for instance. There are those that had some kind of contact with white people, white civilization, and so they would have some civil capacity and some criminal responsibility. So FUNAI, that's the organism competent to make this, to define which community is or not integration, the level of integration. And of course there's also the indigenous communities and indigenous people who are already integrated to white civilization. Yeah. So, and then after we had the 88 constitution, that's our last one. The most part of academic literature says that this constitution has a perspective more multiculturalist, more inclusive, because recognize to indigenous people the right to keep its own culture. Yeah, and so this would be a starting point to finish or to flexibilize this perspective more integrationist. Yeah. And the interesting thing that Pedro already showed is that the land where indigenous people live is federal union's property. Yeah. But the indigenous people, they have possession and usufruct of the natural resources. And that's, of course, the nuclear point of social conflicts involving indigenous people. Yeah. Okay. So I will just, so nowadays we have this contemporary discussion because this statute is still effective. It works yet. I mean, this is still applicable, but we have this, okay, it must be rewritten under this constitution. But of course, this right to keep its own culture, it's not so, would say, detailed. Yeah, and our Supreme Court normally used to protect more some indigenous rights. The last decisions from our Supreme Court, they are more progressive. Yeah, but our Supreme Court also recognize still this 3 level of integration for indigenous people. So we still have some kind of, we still have this discussion, we still have this tension, and it's also discussed in judiciary. Yeah, most part of them are discussed in the judiciary Supreme Court. Yeah, we must wait a little more to see how this will be. For instance, the last tries of our government, this last government we have, the last tries of this government to make some changes in indigenous possession protects were declared unconstitutional by our Supreme Court. That's, for instance, one interesting thing. Okay, so the questions I'd like to make that I'm looking for in this new research I'm making also with indigenous people, that's starting research, but some questions are from also the quilombolas research I did, some of them. So these are some questions that I used to make. So this frozen common sense of colonial traditional perspectives, yeah, from quilombolas about the the prejudice and discrimination from slavery time, yeah, it still operates in institutions and civil society, yeah, so it can be the basis for socio-legal conflicts, just like for indigenous people. If we see here, for instance, an indigenous people with a computer or being a judge, yeah, or just having this white civilization costumes, yeah, those things are source of social conflicts because our society don't recognize them as having rights to be different, I would say like this. So this is a problem for recognition. Yeah, and so these can make us think the practical limits of critical post-colonialism perspective, yeah, to emancipate these minorities. We can think if they are classical social movements that look for changing the structure we have, or if they are new social movements looking for inclusion itself. And in this way, we can, in more restricted way, can think in which measure those strategies for recognition that they used to have are instrumental to fight for inclusion itself. Yeah. So there are some questions that I'm looking for in my research group that I have in my university. Okay, thanks a lot, Oscar. I'm finished.
Thank you. Thank you. Now is the turn of the discussion. I am going to ask some questions to each participant. And the first one is that NEWMAN. Well, my question is the United Nations Declaration part of the solution or part of the problem in the question of collective rights, entitlement, and exercise? And the second question is, in that declaration, indigenous peoples are recognized as legal persons or subjects with legal personality, or this is something ambiguous and indeterminate in that declaration?
Okay, thank you. On the second question, I'll say I don't know if it's entirely determinate, but I think it is implied that Indigenous peoples would have legal standing. In the statement that they hold various rights, I think it's challenging to read it in some other way, but there will be states that attempt to do so. So I don't think it's entirely determinate, but I think it's well on the way to that. On the first question, I guess putting it as, is it part of the problem or part of the solution? I mean, certainly it's a solution overall, but on the specific question and issue of how it deals with collective rights and with issues of entitlement and exercise, it certainly does include some ambiguities in a way that are challenging. I mean, there are reasons why the declaration doesn't contain a definition of Indigenous peoples, partly that Indigenous peoples didn't want to subject themselves to a definition negotiated with states, but that poses some real challenges in some parts of the world more than in others, and especially in African and Asian contexts, there are some real challenges that come from that, and that gives rise in turn to issues related to representation. And again, the declaration focuses on Indigenous peoples themselves defining not just their identity, but also their mechanisms of representation, their political institutions, and so on. There are good reasons for that, but it creates some real challenges in terms of identifying how the exercise of collective rights will take place in every instance. There's a statement of entitlement within the declaration on I think the most plausible reading, although again one that some states will challenge around the concept of collective rights. But the declaration doesn't define as much on the exercise of those as one might wish. That said, it's pretty challenging to do in a universal declaration that applies around the world. And so there's just further work to be done. The declaration can't do everything on its own.
Thank you. Thank you. We continue later. Now is the turn for the question for Pedro and Camila. I want to ask, okay, well, it's very interesting, very, you denounce the situation of the indigenous people in Brazil. What about the inter-American case law, for example, the case Aguas Tigni and so on? It's not applied in the case of Brazil. Or how can be applied this case and the different cases related with Aguas Tigni and so on, with the possession and property, the possession of the indigenous people and the property of other third parties. And more in a conclusion, how it's possible to improve the situation on the indigenous communities in Brazil? How can be improved this situation?
I would like to see if can Camila speak? Can Camila speak? Could Camila speak? Oscar, can you hear me?
Yeah, I can hear you.
Okay. Could we get Camila to speak too?
Yeah, of course. Camila has
okay.
to open the macro. And she can.
Okay,
she
Camila,
can
are you there? Oh, she's trying to. Well, meanwhile, before she comes, I believe I was thinking about the question about the Inter-American Court of Human Rights. Basically, that decision, if I recall well, it obliged Nicaragua to establish a system of demarcation and recognition of indigenous people, original peoples' territories. And in Brazil, we already have that, and we have that on our constitution. So the problem would be that the same way that Brazil does not fulfill its constitution and does not enforce its constitution, it would be very likely that Brazil would not enforce and obey to any inter-American human rights decision. That's a problem in my point of view. And Camila, are you here? Oh, she's trying to, but meanwhile, Camila?
She need to click in the macro. She need to activate the macro.
Yeah.
What is the macro? What is the?
Yeah, I would like her to say some to us. But meanwhile, once again, she's not. I think she's having trouble. But meanwhile, I think that what we need to do is work on the enforcement of constitutional provisions. So, for instance, on the past years, the Indians agency FUNAI has been walking away from its finality, twisting its finality, and we have like budget cuts, for instance, and directors and those who are responsible for leading the agency are being indicated by the presidency, not only with no technical capacity, but also some of them are very much involved with those activities that are pushing the frontier and that are pressing indigenous lands territory. So this would be a first thing, a good start, because we already have many things on our constitution. and we must put them to work. The good news is, and that I would like to say here, it's very important to say that, to register that, is that indigenous people are organizing and fighting from themselves. They have always done that. They have done that always, but now they are starting to do very interesting things. For instance, they have, through the indigenous people articulation, they have initiated a lawsuit in our Supreme Court. They have done that, representing themselves using Article 232. So this is a very interesting thing, and they are doing this more and more. Now with COVID-19 pandemics, we have recently approved a law calling for a emergency plan. So this articulation of indigenous people, original people in Brazil, they have elaborated their own plan. So we need to support them and hear them. And concerning FUNAI, we need to put it back on trail, back on the path it was supposed to. Before FUNAI, there used to exist another agency which was called Indigenous Protection Service, SPE. This service ended after some huge scandals concerning the way the agency was not protecting, but otherwise was treating very badly indigenous people. And that was announced during our dictatorship by a military that was working for the agency and wanted the indigenous to be truly protected. And what we see now nowadays with FUNAI is something very, very strange, very rare, very bizarre. It should be reconsidered, I think, the way it's working. It's nothing. It's no surprise with this government, but even though with this government we should ask for some changes in FUNAI, budget changes on those who are in charge, and philosophy changes too. I hope I have answered your questions. Thank you.
Okay, yes. We follow. I have more questions, but first I want to ask questions to each participant. But yes, it's an interesting view on the indigenous peoples in Brazil. Well, I have a question for Chiaretta. My question is, your paper is very interesting for me because it's a new topic, this cultural food and this right to cultural food. My first question is, okay, food could be commonly understood from a Western point of view as a social right. We have right to food. But in your paper, you clarify that the point is for indigenous people, this food is a cultural right. And also you connect this cultural food with self-determination and with the existence of the group. I would like that you clarify this point in the sense that you are claiming for a cultural right, cultural food right, and what is the connection with self-determination?
Yes, obviously the right to cultural food starts, at least in my paper, as a cultural rights. So from here, then I try to elaborate. So through my article, I try also to arise another issue, because normally culture is considered as a body of norms or values of standard that are like associated with a group, or at least a group is identified through them. But for instance, cultural rights are defined by the Article 27 of the Universal Declaration of Human Rights and Article 15 of the International Covenant on Economic, Social and Cultural Rights. is mainly focused to the enjoyment of arts and scientific advancement. So how come that something that is food that has a vital element in the culture of the people, and I'm talking about any kind of ethnicity, has never been considered? And to do that, I actually use exactly the case of indigenous people, because it's an extreme case where culture has an importance that if it's not maintained, then it can actually destroy an ethnicity. As I said, in 2010, the United Nations Permanent Forum on Indigenous Issues actually stated that there is an escalating process of extinction just because indigenous people are not able to promote their culture as they want. So what I'm claiming here is as Stamatopoulou, that is also, she's a professor, and also she served in the UN for the protection for indigenous people rights. She says that cultural rights are not only for art exhibition or scientific exhibition. They embrace any aspect of the life that promote development and integrity. And so this is the reason why, through the right to culture and together with the human dignity, they are strictly connected to self-realization. What indigenous people claim is their autonomy, to be considered distinct from minority groups and from the rest of the population. So if their traditional food is a vital element through which their identity persists, then the right to cultural food has the important purpose to safeguard their existence and determination. And this is happened because when we talk about food, it's normally considered as we need to provide food, as availability, as a physical access to food. And most of the time, Western food, as I said before in the presentation. But what we are missing, and that when we talk about food, there is collecting food, collecting natural resources. It's about cooking. It's about serving the meal. There are rituals around the meals. Even I'm from Italy, and even in Italy, we have a specific way of serving. We have a kind of ceremonies that in which we are sharing some food respect to others. But when we are talking about indigenous people, their culture is more emphasized. So with the realization of the right to cultural food, indigenous people have the right, or at least what I'm claiming is that they have the right to choose which aspect of their identity they want to save and pass to the future generation, and instead which other part are willing to lose. So we give them the right to self-determine themselves. The link actually between traditional food and self-determination is also highly acclaimed by this political movement that is quite new, that is the food sovereignty, that is considered as the right of people to healthy and culturally appropriate food and their right to define their own food and agriculture system. And I'm referring here because there are a lot of researchers from Brazil. There was actually a case in 2006 of the establishment of this village that I'm pretty sure I'm going to pronounce it wrong, but it's Cinta Vermelha, Jundiba. And this is a case that has attracted a lot of the international attention, because for the first time there was a break between the colonialistic policies and the historic obligation and power against indigenous people. So through this way, indigenous people, and especially in this case of Brazil, this village was able to choose which part of their tradition they were able to pass to the future generation, even food. So, for example, in this village, and even the FAO was able to prove it with the research, they were able, for example, to plant 200 kinds of trees that are used for rituals. They are used, the seeds are used in their meals, in their ceremonies. And so what I'm trying to say is that with the right to cultural food, we are not only promoting the formal equality of right to food that every human being has, regardless of ethnicity, of language, of gender or religion. We are actually promoting the substantive equality. That means we need to promote that positive discrimination that indigenous needs in order to guarantee their self-determination. Oh, I'm not understanding if I get, it's a question, sorry. So yeah, so this is why I'm connecting right to cultural food to self-determination, because this is the way they can actually choose what to maintain and what to lose. That is something that right now with the right to food as it is, they are missing, and is actually seen when they are relocated in urban areas, because they cannot, they don't have the right, they don't have the capability, they don't have the money to do that. And with the right to cultural food and with the claim to the right to cultural food, maybe this is can be promoted and can be enforced for to guarantee a food security in the long term.
Okay, thank you. The question from the public we can ask later. We can ask later.
Okay.
We could be answered later. Then now is the question for María-Cruz LA CHICA. I want to ask, well, I think you have a clear position. Usually there is an approach that says that feminism is opposed to multiculturalism, and I think you belong to this approach, and you think feminism is opposed to collective rights and to multiculturalism. I think from your speech. And okay, my problem with this approach is what about indigenous women in practical terms? Indigenous women lives in communities. And then we can say, okay, yes, feminism, individual rights are very important, and we can denounce this situation. But how can we manage? How can we deal with this situation? And finally, a curiosity: what is your view on the position of indigenous women in Beijing Women Conference of 1995?
Thank you, Oscar. Well, in this paper, I do not pretend to explain my own position in this dilemma, which is very difficult and much bigger than the things that I can explain in this space. But I will ask to the states to have a consistent position in that dilemma. What I mean is that if they are part of conference and treaties and conventions that put the individual rights, for example, like in a very important positions, I want to challenge the states to define their positions and to be consistent. But yes, I agree with those international conventions and treaties about the priority of don't lose the focus in individual rights, especially if the individual rights of those historically dominated groups such as women or the LGBT population or children. And about practical terms, well, I think that the state should know, just in the first step, they must know what system are they recognizing. Just know for the first step. Maybe through surveys if possible, for example. And once these data are known, they must implement public policies in coordination, and this is the most important thing. I think that is impossible without the coordination, the view, and the voice of indigenous women affected by those situations, and with their needs and with their mechanism about their own situation, asking, do you need something? Are you okay with something? What are your needs here in this community, in this settlement? I am sure, because I have seen it, that they have an opinion sometimes. Maybe it's not the most popular opinion, but they have critics about their own systems, and they are fighting for their rights in their own context. But I need this. It is a responsibility of the states to help this fight and this to improve their situation. And about the fourth World Conference of Beijing, well, in the context of this conference, indigenous women were not exactly a topic of the discussion. Although they did have space to meet at the international level and articulate their demands. The NGO Forum drafted the Declaration of the World's Indigenous Women in Beijing in this context. And it requires all governments two things, which I agree, because they are the most important person that have to say that. Two things: that the governments have to recognize the right of indigenous people to self-determination, and it also demands a very clear limit on this right. In the article number 36, they say that the government have to reinforce the judicial systems that are respectful of women victims of violence, that they have to recognize and reinforce them. And also it requires that indigenous law, customs and traditions which are discriminatory against women should be eradicated, they say, eradicated. So I think that this very important event for the history of their rights, but is only in 2014 that we have the first vinculate norm, so it's very recently, about harmful practices. So, well, it's have a lot of time between each requires. Yeah.
Okay, thank you. Now is the question for Monique. Well, I think this Quilombola issue, as you have referred, as you have described them, they're powerless, they are mal-distributed, they are misrecognized in the society. My question is, how is possible the empowerment of this collective? And if they are important in the political agenda or in the human rights reports in Brazil, or they are people who no one talks about?
Yeah, thank you for your question, Oscar. Actually, yes, this is an agenda. There's a lot of social movements that works with the quilombolas, and this is one foundation for some critics that these quilombolas movements receives, because actually they represent themselves, of course, but they also have a lot of help, I would say like this, from other politic groups and politic actors, and that I would say help them how to fight. Yeah, help them to understand their history, to understand their traditions, to understand their role in the civil society, for instance. And so this is interesting because at the same point that they receive some support from some groups from civil society, they are also criticizing because the support they received are seen as like fraud, like they are receiving like artificial, you say, like an artificial fight, you know. It's like it could this delegitimate their fights, can you say, because it's like there are some opposite groups that say, oh no, they are learning how to be quilombolas, and with this learning they can reach some individual rights like property that they wouldn't reach if they did not learn it. If they did not learn this stereotype, I would say like this. This is quite complicated. This is very sensible point in Brazil for quilombolas specifically, because this minority was for the first time recognized in our last constitution. This is completely different from indigenous people. Yeah, the indigenous people were always there, and they were always seen as a different category from white people. Yeah. So what can be the most part of the conflicts with the indigenous people are for land and all these things, but I would say the nature of their difference is consolidated by our history, I would say. But for the quilombolas, the name, the concept of the minority is built since 20 years, and it was put in practice. The public policies were built in the last 10, 20 years. So this is very new. So for civil society to accept them as an ethnic minority is much more difficult, you know, because before the 88 constitution, they were just people like all the other white people, even if they were black or yellow or red or blue. This was not a sign of difference, just like for indigenous people. This was not a natural difference, just like for indigenous people. I don't know if you can understand a little this thing. So from this point of view, yeah, sorry.
Yeah.
Yeah, but I don't know if
I have some problems with the sound and with the... I follow your explanation. Your explanation.
Yeah, sorry. Can you repeat, Oscar?
I have problems with the connection, but I think I have followed generally your explanation.
Okay, yeah, because that's something people ask, because quilombolas, that's one thing. So I don't know if I could, go ahead, but we can make other questions after.
Okay. I have more questions, but now we are open the discussion to other people. There is a question for Chiaretta from Raul. And okay, Ranesh want to talk. There is a question from Chiaretta, and I have more questions. And if Monique wants to talk, okay, Ranesh, is your turn.
Yes, please. Thank you very much, sir. My question is in the chat box for Monique Falco. What was the criteria and consideration of selecting this topic? Because as far as Brazil is concerned, ethnicity is prevailing in every country. In India, there is also such type of ethnicity. That is my humble submission. Would you like to reply that what was the criteria and consideration of selecting this topic? Thank you so much. Thank you.
We can ask all the questions together. There is a question in the chat. Question for Chiaretta is there an international legal instrument that protects the right to food for indigenous people? This is for Chiaretta. And is there any other questions? I want to ask a question for Dwight NEWMAN about the balance between individual rights and collective rights in the United Nations Declaration. There is clear, I think this is the key point, the balance between individual rights and collective rights. There is some light in the United Declarations between the balance between individual rights and collective rights. And I would like a word about gender equality and minorities within the minority, minorities in the indigenous people. In the United Nations Declaration, there is something about gender equality, there is about the minorities within the minority. And from the two papers from Brazil, from the paper of Pedro and the paper of Monique, I want to ask the question of, you, Pedro, said that what is important is the Constitution recognize collective rights for the minorities, for the indigenous people. But yesterday we saw we have discussed the question of the animal rights and the active role of the judges. My curiosity is how the judges, the Brazilian judges, deal with indigenous people, with the indigenous people and with indigenous rights. Are Brazilian judges commonly, generally speaking, progressive, or are more conservative, or there are certain rules, certain rulings progressive, certain rulings conservative? That are my questions. Thank you. I don't know in what order do you want to answer? Maybe in the order of the questions. Then, Monique, could you answer the question of Ranesh?
Yeah, sure. So when I chose to work with quilombolas, actually it's because I wanted to talk about to work with minorities, because my mainly topic was recognition and social movements. So when I saw, for instance, the quilombolas and the way they were fighting and all the historical background they had, I mean the historical background behind the concept of quilombola, that was upon I based my problem of research. Yeah, because we see in the civil society a lot of different meanings that they flow, like Foucault says, micro power. Yeah, so those micro powers, they can build the social actions, and of course the prejudice and discrimination becomes in practice. So that was the background for quilombolas, and it was quite interesting because in Brazil we have a lot of different meanings or social representations for Black people. Yeah, because there are another fight between, for instance, people who live in favela, the Black people who live in favela are quilombolas or not, because, okay, in the end of the day, everybody is somehow descendant of some slave in Brazil. So these questions to define who is not, and how in the criteria to define who is not, because, okay, you have the legal criteria, but you also have the social criteria, the social power, and all these things. So I studied a specific community in the south area of Rio de Janeiro. This community of quilombolas was completely different from all the others because it was in a very rich urban area. And so the main question was, how can a community descendant of ex-slaves, and normally these ex-slaves must be in a very far away inside the forest somehow, how these communities just appeared in the most expensive urban area of Rio de Janeiro, that's Lagoa Rodrigo de Freitas. And so those things came to me. That's why I choose this topic, because when you go to social reality, we can see that a lot of theoretical concepts about recognition, about identity, that we normally see here in Europe, for instance, and they are really different from social reality. But this is another topic. This is another thing to think about. Yeah, I don't know if I answered, but yeah, okay. Thanks a lot.
Okay, then the question for Chiaretta. I think she has problems with the connection. Then the question for Dwight NEWMAN about the balance between individual and collective rights in the UN Declaration and the gender equality.
Yeah, thanks for the question. I think there's a lot one could say on it. The Declaration says less on it than it could in terms of minorities within minorities generally. On gender equality, Article 44 of the Declaration, though, says that all the rights and freedoms in it are equally guaranteed to male and female Indigenous individuals. Just what that means, I think there's room to engage in some interpretation, whether that's saying that the collective rights also need to be understood in a way that ensures that there's respect for male and female individuals in the course of that. I think would be an important interpretation, but it's not one that's clear on the text, but it might be one that could be developed over time. Certainly the individual rights within the Declaration, there's a statement that they're guaranteed equally to male and female individuals, but how that applies to the collective rights is a bit more challenging. And then, of course, this aspect where the collective people has the ability to define the responsibilities of individual members within it. I mean, that's right in some senses, and that's what the text says, but that could give rise to challenging questions on gender. That said, I mean, those are challenges in every community. They're not unique to Indigenous communities. But in terms of wrestling with all of the questions that could arise, there would have been room for more text. In the absence of it, there's room for ongoing work to reach good, constructive interpretations that respect all the interests.
Okay, thank you. Now, Chiaretta, if you can talk, you have good connection now.
Can you hear me?
Chiaretta?
Yeah, can you hear me?
Chiaretta, the question about...
Okay.
Yeah, we can hear you.
Yeah.
You know the question? The question from the chat?
So the question was about if there is a legal instrument to protect the right to food of Indigenous people, and is actually an interesting question, because while I was reading the United Declaration of for Indigenous people for the protection of the rights of Indigenous people, I was looking that they were all the articles, not like, I mean, like they were promoting self-determination, but none of them was referring to food. And even the ILO conventions for the protection of the tribes and the tribal people never mention food. Another, well, there is the general comment number 12 of the Committee for on Economic, Social and Cultural Rights, that has recognized the right to adequate food. And be considered a good way, a good way to promote the traditional food of indigenous people. However, a few years later, the special rapporteur on the right to food clarified that when it meant to be adequate food, it means considering the age, the living condition, the health, the sex, but never refer to the ethnicity. So right now there is no actual way to protect the right to food of indigenous people, and this is, I think, the reason why, because normally cultural food, or at least culture, is not referred to food. So there never had to be a reason to consider the aspect of the culture that is the culinary tradition of indigenous people, or even, as I said before, in the future maybe it can be also discovered that for other minority groups it could be important to protect their traditional food for their health even. Is because there never been a reference to that aspect of food, to the anthropological, to the psychological, to the social meaning of food. And so this is why it's important to go through this aspect, and probably the best way could be to give a more legal protection to this political movement of food sovereignty that in some countries of South America start to be constitutionalized, but in other parts it's just a political movement. So yes, right now there is not a legal instrument that protects the right to food. And as again, I want to underline it, when I'm saying right to food to indigenous people, I mean the substantive aspect of the right to food. So as a positive discrimination, it means giving empower to the traditional food of indigenous people.
Okay.
Yeah.
Thank you. Now, my question for Pedro and Monique, if she wants to talk about the activist or conservative judge in Brazil about the indigenous people.
I can't hear it.
Monique, you wanna talk some about that?
Yeah, sorry.
Okay, then I talk.
No, Pedro, you can talk first. Then I go on. Yeah.
Oh, really? Okay. Well, in my opinion, it's very hard to say to affirm that judges this, judges that, because Brazil is a huge country with hundreds and hundreds of judges. So it's difficult to say that in general judges have a progressive perception about indigenous rights, and the other way around, be just as delicate to do that. What I hear usually when for instance, lately I've been watching some lives from indigenous peoples, and they complain that many times it's their complaint, okay? In those lives I've seen that the judges usually they don't pay attention to their rights. So in many cases, civil law procedural laws are not observed correctly accordingly when it comes to indigenous peoples, and that may cause some very uh, important consequences in the future, because when when a case comes from the first instance, we called, or the single judge, and then the court, and then it goes to Supreme Court or Superior Court of Justice. Usually, when it arrives at the Superior Court of Justice or at our Supreme Court, by the use of a legal appeal, for instance, the judges have limitations when it concerns re-examining facts. So on the other hand, when the procedure, when the suit, when the legal action starts at the Supreme Court, then they have a liberty to look on those aspects. But it's hard to say if they are progressive or not. My hint, if I would guess something, I would guess that they are not progressive. With some very good exceptions, they are not progressive. This is what I heard from some indigenous people in the latest lives I've heard.
Okay, so I'd like to make a different point of view and to say that in another way, I would say that they can be seen as progressive when they deal to some collective rights. I would say like this, for instance, the original lawsuits in the Supreme Court, actually the lawsuits for the unconstitutional declarations, for instance, they are quite progressive in a specific way. When they, for instance, they can stop some economic interests that can be prejudicial for indigenous rights. We can see this, for instance, in the case of Belo Monte, in another case of Raposa Serra do Sol, in which there were a lot of economic interests from miners, for instance, from agribusiness and all these things, and they could be stopped in front, considering some Supreme Court decisions. But this is important to say that these decisions, sometimes they cannot be completely applicable in concrete, because the social reality, the violence for land conflicts, unfortunately they don't respect these decisions from Supreme Court. And there's also something very interesting, because when we see the conflict between the Statute of Indians from 1973, the one that says that has an integrationist perspective, yeah, and this is criticized by the post-colonialism thinking, I would say like this. So when we have this statute from 1973, and for instance the constitution from 1988, and when it goes to Supreme Court, then in this case sometimes the individual rights of indigenous people, they of course maybe the decisions can be not so progressive, because they are a little more legalist, because they still think that the Statute of India is constitutional, and that's why the National Congress, the Parliament, is still analyzing a lot of other projects of law to regulate or new regulate the indigenous legal regime, I would say last week, to substitute this statute of law, the statute for Indians from 1973. So in this way, they can be not so progressive as the post-colonialists or as the indigenous people would like them to be. Yeah. But on the other hand, I would say that for instance, to protect the land and the possession of the indigenous people, for instance, STF has been a good protagonist against, for instance, some decisions, some recent decision from executive power. Yeah, our recent president, everybody knows who is this. They take some decisions, some decided to have some strategies by the executive power to reduce the protection of land in the lands of indigenous people. Yeah. And the STF, our Supreme Court, declare all of them unconstitutional. So from this point of view, it can be quite interesting. So, but in a general way, in Brazil, the the judiciary power, even if it's very conservative, for instance, also just like Pedro said, it can be also seen, for instance, for the quilombolas. Normally, the first instance, just like they said, in an atomic view. So if you take the single judges, when they judge, for instance, some lawsuits involving quilombolas, lands for quilombolas, and all these things, they normally are more conservative, yeah. But after the Supreme Court declared constitutional the legal regime to recognize the quilombolas' identity procedure and the quilombolas' property regime, legal regime, then the first instance, for instance, they have to apply this understanding of the Supreme Court, yeah. But it's not, this is in a general way, of course, but if we talk directly to the social movements, they normally used to say that their rights are not so, protected by judiciary in a general way, because they are on the front, so they have to fight to the economic power straight with the first instance of the judiciary. But the Supreme Court itself normally is a kind of a protagonist in Brazil. Okay, once again, it doesn't mean that the social reality will have his conflicts reduced, because they are two very different levels of realities and application of law, I would say, like this. Yeah. I don't know, Oscar, if I could answer your question. Thank you.
Yeah. Okay. A final question. We have a final question. Does anyone wants to ask a final question? Yes, Ranesh.
Yes, sir. Thank you so much, sir. I have also asked in the chat box, is there a crisis of conflict?
Where is Ramesh?
Here, I don't know, but he is not. He's out. Well, yes. Okay.
I'd like to make a question if I can.
Monique? Oh, of course.
Yes. I mean, it's not actually a question. It's only I think I saw it when from María-Cruz. I found very brave her position, actually, because this is something that normally when we are studying and looking for minorities and studying all these things, we have normally an instinct to emancipate all minorities and all cultural traditions, just like if they were the only thing that could be the most powerful thing for minority recognition. But when we go to social reality, for instance, we also see something that it's interesting, because even if they have their traditions, even if they have their specificities, they also change, just like every culture does. And when I was studying the quilombolas, for instance, and I saw, for instance, this community, I will not talk about it now, but when I saw this community of quilombola, completely different of his stereotype, the old stereotype, and a completely different of the legal definition of quilombola, and completely different of all the other 3,000 quilombolas communities that we already have recognized in Brazil. And they were also recognized as quilombola community. When I went to study deeper the anthropological criteria of they have historical process and the common cohesion and all these things, I could realize that the expression of the activities, I mean, the expression itself, it's only a part of their identity. Yeah, it's only a part of their recognition. When we see the indigenous people, for instance, that they have these nowadays with the globalization, they want to use all technology that everybody uses. These seem as a good thing to emancipate them. But when we talk, for instance, some individual rights of woman or of child, this cannot be touched, because if we touch this, then we will cut their traditional culture, for instance. I would say that this is something that we really should make a kind of, you know, how can I say, put this in a balance. Because if we recognize that they can have access to all goods and justice system that we have in the globalized world, so maybe we can also think that they can also maybe we can also recognize that some individual rights for women, for children, for other things, some may also can be protected, of course, because in these people. There's a French author, it's quite old, but for me it's a classic. This is Dubar. He talked about how the identities, they change during the decades and during the generations and during the space and time, you know. And but in the end, we always have some essence, some nuclear identity for us, even if our activities, exterior activities can change to be arranged with the whole context. So this is something that I'd like to congratulate Maria Chica for her vision, because it was really brave. Normally, and mostly in the current literature that we have for minorities and all these things. And that's it, Maria Chica. It's only this. Thanks a lot.
Oh, thank you, and sorry because my internet switched off in the first part of your comment, and I'm not sure if you have asked me something specific or just comment about the issue.
Yeah, I could not. I did not make a specific answer. I just make a comment because I could find very interesting how you did this approach, you know, this to mark, verifying this individual right, that you take the woman and you take the gender question. But it can also be for any kind of individual right. I mean, when we talk about the life, when you talk about the physical integrity, when you talk about the psychological integrity of a human being. Yeah. So this is something that normally is attacked in name of culture, in name of tradition. I totally understand, but I also think that if we attack this nuclear value of integrity, life integrity, the physical integrity, the psychological integrity of any kind of living being, yeah. So this for me is also a way to say that these minorities, they should be, for instance, isolated in their old traditions. I don't know, but this is like if it's like I'm reading Levi Strauss and the critics that he did, you know, in conference making ONU in the 70s, and also, for instance, Clifford Geertz and all those anthropologists. They're really, I would say, quite critics of this isolated way to say, you know. I don't know. That's why this is one question for you. What do you think about it?
Well, I was studying for my PhD. I am from literature discipline, and years ago I was started to read about Tojolabal people in Mexico to study in my PhD research about their literature, and I was reading all things that I could find about Tojolabal indigenous in the south of Mexico, and I have never read anything about women, Tojolabal women. anything. No one paper. It's incredible because when I was there for starting my field work, the first girl that I know was a Tojolabal girl who was working in a friends of mine house, and she was talking me about her culture, her community, her problems, I don't know, whatever. And in a point of more confidence, she was talking about how she had to go outside to the community because he was raped by a man, and she was forced to marry this man, the rapist, because of the community forced her to do it. She started to cry in this point. And I was just 2 weeks in these settlements. In 2 weeks, I have noticed about a case. So I couldn't believe how many anthropologists before me didn't talk anything about that. It's incredible. It's just incredible. And I finished my PhD on literature, traditional literature, finding many most cases in these settlements, and I think they are claiming of also people who can maybe the power to talk about these cases outside the community, not to silence the cases like many anthropologists we used to do, because of this stereotype vision of harmonious paradise that we have sometimes, because because we need this paradise, but not them. Sometimes I think which is the question is that we are constructing some paradise that we need, and what is the effect of our construction among the academic studies? What is the effect for vulnerable people? Yeah, I don't know if I have answered, but thank you.
Yes, thanks a lot. And yes, you're right. I totally agree, because it's not only, for instance, we talk about gender, we talk about women, but we also can see this for other living beings. Yeah, it depends on the culture. You have this to children, you have this to old people, you have this to, for instance, in India, you have this to the lowest castes, and it depends on all the in name of tradition to do this kind of thing. Yeah, okay. I totally agree. Yes, thanks a lot.
Thank you.
Thanks, Oscar.
Okay, thank you. Well, I have had problems with the connection. I cannot follow all the speeches, but it's okay. Okay, well, I think it's late. We can finish now. We have to thank all the speakers. Thank you very much, all the participants. Thank you for being with us. Thank you for joining this webinar. And the last session of the webinar will be the 4th of August about indigenous people and natural resources. I think today has been a great discussion, very interesting points. And thank you very much to all. And okay, well, I have to tell that the book will be a paper edition and will be an ebook. And in order to publish the book, we need the papers at the beginning of August, the definitive version of the papers at the beginning of August. And what more things, Monique? Okay, the video will be tomorrow. I will send video tomorrow, and I will send you the video of all the sessions of the webinar. Monique, do you want to say something?
No, I'd like to say that Chiaretta, that I'd like to have talked to her a little about the question about foods, but we can maybe talk about it a little after. And yes, it's this, and I'd like to thank you everybody for being here today. It was really amazing afternoon that we had together. I hope we can have more of this because it's really amazing. And yes, that's it. Oscar already did all the things that's the formal things that we should know, and I hope we can see each other again. There's this, and I guess the Ramesh wants to talk something.
Okay.
Also.